Welcome to this MeDiMi lecture on states' practices before human rights courts, a Nordic perspective. This is in total only the second MeDiMi lecture in total, but the first in Amsterdam. And here in Amsterdam, it is hosted not only by the MeDiMi project, but also by the Amsterdam Center for Migration and Refugee Law and VU Vices, so the Interdisciplinary Center for European Studies here at the VU. My name is Jana Wessels. I am one of the 10 PIs of the MeDiMi project. And the MeDiMi project itself is an interdisciplinary research group that researches human rights discourse in migration societies. And we study the scope, forms, and consequences of the expansion of human rights discourse in migration societies. Ultimately, we aim to develop a theory of the dynamic interplay of legalization, politicization, and everyday practice of human rights in migration societies. Now, we're 10 PIs and we have 4 years, so we'll try. The sub-project based here in Amsterdam focuses on the legal context, so the legalization side of things. There's 3 other projects that also do legal things. We're one of them, and we're a team of 3. Together with me, Jessica Kluger and Monica Avila are working on this here in Amsterdam. And they're also the organizers really of this event, so thank you already at this point to you both for this. So in the legal context, international legal standards of human rights provide an important benchmark for migration law practice. And the last decades have seen a significant expansion of migration case law by international human rights courts. So there's more human rights jurisprudence on that. So they constitute, the courts and treaty bodies constitute key fora for what we call in the MeDiMi context, the humanrightization, the expansion of human rights in legal discourse on migration. However, those looking at such human rights courts, so research that has studied the practices before human rights courts, so far has mainly focused on analyzing the strategic litigation of advocacy groups, the migrant side of things, and the subtle mechanisms that states use to influence the court's decisions have hardly been studied so far. And one of the core questions that we then, as a sub-project of MeDiMi, ask is how do governments, be it as responding parties in pending cases, as third-party intervenors or otherwise, act in those fora and around those fora? So what are states' practices before human rights courts? What types of arguments are used to mitigate constraints on migration policy? And we're very happy that Thomas Gammeltoft-Hansen, a distinguished legal scholar and expert in the field of human rights and migration law, has accepted our invitation to give a lecture or a Nordic perspective on these questions for us. Nordic countries, and in particular Denmark and Sweden, as we'll hear in a moment, have featured very prominently in human rights case law. Now, Thomas Gammeltoft-Hansen clearly needs no introduction in this context because he is one of the most prominent and prolific scholars in the field of migration, asylum, and refugee law. But I'll quickly introduce you anyway. So he's a professor of international refugee and migration law at the University of Copenhagen. He also a PhD in international law, and he has worked at several important institutions, including the Danish Institute for Human Rights and the Raoul I don't know how to pronounce this properly, the Raoul Wallenberg Institute of Human Rights. But most recently, his most recent exciting endeavor is a new center. He serves now as the director of Mobile, which is the Center of Excellence on Global Mobility Law, and he leads the Nordic Asylum Law and Data Lab. Now, Mobile does pioneering, you may be able to say it more and better, but pioneering interdisciplinary research in computer science and migration law. And that will no doubt shape academic discourse and policy development in this field in the future. But now I would like to invite you, Thomas, to tell us how Nordic states have politically responded to the growing international judicialization in the migration domain. Thomas will speak for about 35-40 minutes, and after that we'll have ample time for discussion, questions on the talk, also beyond anything you've ever wanted to ask Thomas Gammeltoft-Hansen. You'll have the opportunity to ask. So, Thomas, you have the floor.
Thank you very much. And thank you for this very kind invitation and introduction, first of all to Jana, but also to the co-organizers, the various institutions. It's a great pleasure to be back. I used to spend much more time here because I have long-standing research collaborations with people at the FU, and particularly at the law school. And so it's a great pleasure to be back and to reconnect also with the William thesis. Now, as Jana mentioned, right now I'm mainly working on this agenda for the new center project. And in addition, as you mentioned, we run something called the Nordic Asylum Law and Data Lab, which connects 5 different interrelated research projects that basically analyze large-scale repositories of, right now, principally asylum decisions from Denmark, Norway, and Sweden, and try and sort of empirically extract and correlate findings from that. So that forms a little bit of the backdrop. It's a very interdisciplinary team. We have computer scientists, lawyers from each country, but then also social medicine researchers, critical data sociologists, scholars, etc. The other thing that I'll be talking from today is, in a sense, a little bit my past experience, which has been, as Jana mentioned, working as research director at 2 different national human rights institutes, the Danish one, which is a national human rights institute under the Paris Principles, and then the Raoul Wallenberg Institute. It's not an institute in the Paris Principles, but it's nonetheless the primary human rights institute in Sweden, England. And I've also been part-time affiliated to the University of Oslo. So there's been a lot of practical engagement also in that context with states and government agencies in terms of how do they deal with this particular issue. And I should also mention that for at least a brief period of 4 years, I was a part-time member of the Danish Refugee Appeals Board, nominated by the Danish Refugee Council and NGO, but also gives a little bit of a first-hand view into how these things are being decided. Now, I wanted to try and speak as closely as possible to the MeDiMi projects. And what I'd like to do today is give you maybe a little bit of a context for how the Nordic countries have come to appear so prominently in international human rights discourse on migration. And then think a little bit through also in terms of kind of practical examples of what have Nordic states, and there I'll be principally talking from the Danish perspective, which is all things equal, the one I do know the best, have been trying to respond to this. And one thing is what goes on in the courts themselves, but I'll take the liberty of expanding a little bit and talk a lot about also what gone outside of the courts, but in direct relation to this sort of growing international human rights jurisprudence. Now, very quick backdrop. I mean, I have elsewhere written that the Nordics have sort of undergone what you might call a slow U-turn when it comes to asylum and immigration policy, especially in the ways that they relate to international law. Doesn't mean that they're worst in class now, but it's definitely true that they used to be more enthusiastic about this project. Yeah, so the Refugee Convention, the 1951 Convention relating to the status of refugees, was negotiated under Danish chairmanship. This guy, Knud Larsen, was very, very instrumental in terms of brokering the entire compromise. Denmark was naturally then also the first country to sign. Other Nordic states followed. The Nordic states, of course, pioneered free movement significantly before the rest of the EU, and used to be very proud of the free movement regime. Maybe less so today. We might need people like Stefan to do a few more border crossings in the Nordic countries. Yeah, and what we've seen is that at sort of different tempo shifts. So it's not been a uniform shift all at once, but at different moments in time, there has been sort of like a growing shift towards more restrictive policy making. Yeah. So the most prominent case, the ones that has attracted most headlines, is arguably the Danish. For a long time, the Danish, one of them, the governments had this counter that was displayed very prominently on the front page of the Immigration Ministry's website. We simply counted how many restrictive amendments they had made to the Danish Aliens Act. So it was sort of like a running tally. Of course, we had a minister that was famous for celebrating restrictive amendment number 50 with cake. And you've seen this shift happen a little bit later. I mean, you can say in Denmark, the significant turning point, there was certainly restrictive elements prior to that, but this really significant turning point has been around the year 2001, where we saw a right-wing government supported by a sort of more distinctively anti-immigration party, the Danish People Party, come in. Norway has had different periods where they've sort of like pushed a more restrictive agenda, both in the mid-zeros and then again later, more significantly. Sweden, that was of course known for many years to, in a sense, keep up a more liberal view, especially in regard to international refugee law and in terms of European asylum law, for a long time tried to push up an interpretation of the EU minimum standards of the common European asylum system by saying, well, you know, we want to set an example of being more liberal. Many would say it changed significantly also in the context of 2015 and the large numbers of asylum seekers that Sweden saw in and around that period. I'll come back to the stats on that as well. So we are in a strange position now where for the first time in more than 20 years, the Nordic countries seem more or less unified in this regard, but unified in a way that there is a strong consensus across the sort of governing coalitions in the Nordic countries towards a more restrictive direction for asylum and immigration policy. The possible outlier is Iceland, that has never seen so many asylum cases, but we can talk more about that in the discussion. Now, just to give you a sense of what we're actually talking about, I showed you the counter. The part of my team, what we've been doing also is collecting basic data on legislative amendments. And so you can very clearly see what I was talking about there, that the pace for legislative amendments really picks up from around 2000, and the most significant one was actually in 2002 and onwards. And it has then sort of generally increased, and then maybe there is a bit of a drop now in recent years that we kind of reached peak immigration reform intensity in the years immediately after 2015. Maybe not surprising. Of course, some of these amendments are purely technical. It might be adjusting the Danish legal rules to those parts of the EU legal framework that Denmark does comply with. We have a legal opt-out, so it's not all parts. But the significant substantive changes have tended overall to be in the restrictive direction, which is a few examples of sort of them loosening up ever so slightly, but then pushing back again. Now, if you look at this in context of sort of arrivals, you'll see that, well, all the Nordic countries have sort of experienced peaks and ebbs in this area, but Sweden is indeed an outlier. Of course, it's also a somewhat larger country in terms of population than the other Nordic countries. But as compared to the other Nordic countries, we still see significant higher number of asylum applicants, and we certainly had a very large peak there. If you turn that into sort of annual percentage change and go even back further, you get to see that, in fact, the Nordic countries have experienced these peaks at very different points in time. Yeah, so in terms of relative change from year to year, Sweden actually saw the most dramatic increases, arguably from a starting point of low numbers, but back around the Balkan Wars and then the Yugoslav refugee crisis. And Norway saw it towards the later end of the 90s, which was a mix of both people from the Balkans, Afghanistan, and other countries. Sweden saw, Denmark saw the peak in the Yugoslav crisis. That was my bad. And Sweden sort of have seen sort of dramatic increases a bit later, and again very early in the 90s. So it's not a uniform picture, and that's also important in terms of figuring out, okay, so why is it that we see both significant differences in periods of alignment when it comes to sort of the legislative developments and the responses to human rights in regard to migrants in these countries? And then another thing to be, I think, mindful of is the sort of particular context of the Nordics. So what type of legislative strategies have been adopted here? And I think it's just important to briefly underline that, well, the Nordic countries are going to be very different in terms of legislative measures they're going to adopt in the immigration domain, because they're not typically the kind of frontline states for major arrivals of asylum seekers. The possible exception is Norway, which in periods have seen quite large numbers from the Russian-Norwegian border. So the geopolitics plays in a little bit here, in the sense that we tend to be further up in the chain. At least that has been the sort of normal understanding in the Nordic or Scandinavian countries. The second part is that socioeconomic factors may play in, real or imagined. Some of you may have read that is he Hungarian? Slavoj Žižek? Slovenian. Oh, so sorry. Terrible. So he wrote in the immediate aftermath of 2015 an op-ed in the London Review of Books, where I think it was titled something like "There's no place called Norway," and this idea of that the imagined idea that everyone wanted to go to the Scandinavian countries if you happen to be an asylum seeker or refugee. It's interesting, of course, that I think, you know, if you look at the Ukrainian refugee crisis unfolding right now, and you know, for the first time, refugees actually have free movement, and I think we proved collectively, Slavoj Žižek wrong in assuming that, you know, this would be the panacea, but it has had a significant impact on policymaking. This idea that the Scandinavian welfare states was something that needed protecting, that they're sort of bound by this sort of fairly high both tax level, but also level of social welfare, education, rights to housing, and many other things. And then you can say the legal landscape, finally, it's also important to keep in mind. Yeah, so when we talk about the Nordic countries, well, it's only 2 of them that are fully obliged by EU asylum and immigration law, namely Finland and Sweden. Then on the other side, you have Norway and Iceland that are not members at all. And as mentioned, legal opt-out, meaning that we are part of certain elements, but then outside of others. And then on top of that, we have this strange thing called parallel agreements. So we have a parallel agreement that allows us to participate in Dublin and Eurodac, and we have a protocol to our opt-out clause that nonetheless general picture that has emerged in terms of the sort of policy and legislative direction is what you might call indirect attempts. It's not necessarily legislative measures that have so most of these measures tend to target the rights and conditions of people after they arrive. And the underlying logic is to make better thy neighbor dynamic in terms of pushing them elsewhere. So very much built around this push-pull notion. And it means that a lot of these measures sort of govern things that might sort of also in so it might be things like access to permanent residence permits, shortening the periods of residence permits, but prolonging the period that is needed to obtain permanent residence or even nationality. As we've seen in Denmark, you've had examples trying to have more active reassessment and relocation policies in terms of withdrawing resident permits based on international protection in the case that conditions were seen to improve in the home country. This particularly relates to Syrian refugees. And then it becomes about then access to sort of associated rights, so access to family unification, where again, that has been either delayed or almost excluded, but for different categories across some of the Nordic countries. Denmark most famously, we'll come back to that, introduced a rule first in 2015 and then expanded it in 2016 that ultimately meant that you had to wait 3 years as a person who had received refugee status, but not as a convention refugee, but a tertiary status in order to get family unification. Then it's become about access to welfare, social benefits, access to labor market. Education is an area where also both Denmark and Norway has kind of played the legal geography in a sense that they could basically become more restrictive, at least on paper, than what would apply in other European countries, at least EU member states. So the picture here is from a period where the Danish government required certain categories of asylum seekers, principally single males, to live in tents, even at a time where we had adequate housing in the asylum centers. So you can see sort of how these sort of draconian policies, it's not just a question of only saving money, but it's very much also about signaling. And that's maybe also sort of, if we go back to the slide here, a part of it, that the way that Denmark, Norway, and maybe more recently Sweden has tried to position themselves, maybe now also Finland, has been through what you might call negative nation branding. So it's very rare that you would actively portray a negative picture and an unwelcoming picture of your country. But that has certainly been the case in the strategic outlook here. And hence, Denmark, for instance, took out newspaper advertisements in Middle Eastern newspapers, sort of explaining in Arabic about the restrictive conditions in Denmark. Norway had a Facebook campaign, and at a period you could see also in international newspapers, you saw the different Nordic ministers kind of competing and saying, well, now we are the most restrictive country in Europe. And sort of this sort of negative nation branding, we know it a little bit from the Australian context, where you also have this. I mean, if you've ever walked through one of the major transit airports in Southeast Asia, you will have seen some of these huge, like sometimes 6 meter long, no way campaign banners and sort of very dramatic pictures in this regard. So let's just get aside. But that's sort of part of the backdrop, and it plays into, of course, the composition of human rights. So here we see from Denmark, the sort of composition of immigration based on education, that's the yellow, work, that's the white, family unification, that's the pink, and asylum, that's the orange. And what's interesting was that, I mean, even though those numbers, the asylum and family unification numbers, are by far the smallest, it's where everything is concentrated. Yeah, so you have, on the one hand, a sort of skewage in terms of what is being litigated and where policy is being directed. And secondly, a skewage in terms of the types of measures that are being implemented. I'll just talk about a few things because that's where we see most of the international jurisprudence. But in fact, I think exactly this indirect deterrence measure logic means that we may well see completely new types of also international litigation in this area that has much more to do with non-discrimination, and in a sense also in that sense see some shift in terms of the kinds of international actors that might engage in this. Now, to turn the tables and look at the international picture, some of you will know this very well, but bear with me. I just think it's important to underline. I mean, what Nordic countries have been dealing with and why the sort of international human rights jurisprudence has become a particular issue relates to the fact that what migration scholars often call the human rights term. The idea that from the side of refugee law and migration law, there was a turn towards the international human rights framework to embrace it. That was certainly not also in scholarly circles the norm. If you go far enough back, you have also Nordic scholars that were sort of very, very keen to say, well, refugee law has nothing to do with human rights. And the reverse dynamic is then, of course, that suddenly that connection point that also happened sort of towards the end of the Cold War opened up new litigative avenues. Yeah, so prior to the sort of 2000, you saw very few immigration cases before, for instance, the European Court of Human Rights, which is what you see here. And then we've seen a quite dramatic increase and maybe a small tendency towards decrease. And as you have pulled the numbers for the last few years, maybe do you know it, Paul, by heart? No, not at all. But it sort of suggests that something significant systemic is shifting. Yeah, and we can go into the causes for that, the way that national lawyers representing foreigners become more engaged in the type of and simply learn how to do litigation, which is something that, especially in small countries like the Nordic, would not be common knowledge. And there's a certain litigative moment also where a number of the major civil society organizations get more heavily invested in kind of pursuing international litigation as well. Now, One thing, of course, is the substantive European Court of Human Rights case law, but there's, of course, also the Rule 39 measures that for a very long time similarly dominated the immigration domain. We could say the immigration domain dominated Rule 39 submissions. And it's interesting because, again, you can see here, if we zoom in on the kind of 4 major Nordic countries, there were a very large number of these, not in all countries, but principally in Sweden and in Finland. And if we go back a little over 10 years, actually a large number of those measures were also granted, sort of from 41 to 71%, depending on the country. And then we see a drop, yeah, and that drop happens across all of Europe, and it comes with a pushback also internally from the former presidents of the European Court of Human Rights, the idea that the court should not be a court of appeal for immigration cases. And so it goes almost out of fashion. And if you look at sort of the current numbers, it's sort of next to no cases, and I mean, this is hardly even statistically significant, but also very few measures granted in this regard. But something happened also. So one thing is that we've seen a human rights turn, but that turn initially seemed almost exclusively concentrated on a single legal regime, namely the European Court of Human Rights, which of course makes sense again from a Nordic perspective if you don't necessarily have access to EU law in this context. But as this drop happens, something else happens, and that is there's a similar boom in individual submissions to the various UN human rights treaty bodies. And I mean, others have written more about that, and you can get a sense of the global picture, but it's maybe worth just emphasizing that the issue of non-refoulement is the single most litigated issue in individual cases before the UN treaty bodies. And at a certain point, I think it was more than 70% of the docket of pending cases before the Convention Committee Against Torture, the CAT Committee, sorry. And I mean, that's really saying something. I mean, it's not like we don't have issues of torture or ill treatment in other parts, and maybe also in Europe, that isn't directly related to pushing people back across the border. But this idea of kind of mainstreaming core norms from human rights into the human rights litigative system is really taken a very significant foothold. And again, the Nordic countries play a role here, or you should rather say some of the Nordic countries, because as Jana mentioned, what you can see here is sort of the way that Sweden and Denmark is very significantly overrepresented in the statistics. And it also, I mean, we could have taken the other top cases, and Denmark and Sweden would still feature very much in the sort of top, especially as compared to the sort of population and country sizes. I should say that some of these stats here is work conducted by my former PhD student, Sarah Scott Ford, for a dissertation she just handed in and defended last year, which is called Entangled Asylum, which now soon out as a book. So watch out for that at Bristol University Press. So what you can see is that, yes, there's an overrepresentation, but there's also a moment where you suddenly start seeing more findings of violations. And again, the picture is not uniform. Yeah. So if we compare the top 2 countries, Sweden and Denmark, what's interesting is that whereas in Denmark, this is something that really comes very late. Yeah. So Denmark being the first country to sort of take that restrictive turn, it isn't directly mirrored in the way that cases move up towards the UN treaty bodies. That's much more the case in Sweden, that has a sort of more kind of like slow moving and long durée tradition in this regard, where finding of violations happen sort of throughout at different moments in time. So Denmark experiences this huge peak, and it's again suggests that, you know, the local legal context might matter. One of the things that may account for also this difference between, at least between Norway, Sweden, and Denmark, also has to do with how fast it is to move through the national legal system. So it's in terms of exhausting remedies, when you can move up, rules also in terms of financial support for practicing lawyers, bringing these cases forward. That used to be almost automatic in Denmark. And then, funnily enough, and this gets us a little bit towards a topic, sort of how do states respond to international litigation? Well, they removed it. So they removed the financial compensation, and then you see that it starts moving down, and it has remained somewhat lower in recent years. It's very few lawyers that really take on the majority of these cases, which again is not the case in the industry. So something is going on, and it's also interesting then in that regard, combined with these more restrictive measures being pioneered by Nordic countries, that if you look at the immigration law or the immigration case law coming out of the UN treaty bodies, the Nordic countries very often are kind of in the nexus, in much the same way as you might argue that, for instance, the Netherlands or the UK used to be for certain elements around, for example, EU law or Strasbourg law. So you have a lot of sort of important new ground being brokered from UN treaty bodies hearing cases concerning some of these Nordic countries. So and again, something that Sarah writes much more about in the book, so check it out. Now, the second dynamic, and I'll then sort of stop that part and move to sort of the strategizing side, is just to make sure that, I mean, of course, just as there can be these sort of like ebbs and flows, yeah. So one route closes down, then litigation moves into new territories. You of course still have also jurisprudential linkages between the different international legal institutions. The most classic one is between the European Court of Justice and the European Court of Human Rights, where you see cross-referencing. Again, there's been great work on that done from the University of Copenhagen law faculty, from my former center in I-Court, basically showing that this type of cross-citation between, for instance, the Court of Justice of the EU and the Strasbourg Court is actually much more pronounced in the immigration domain than it is sort of across the board. There's one other domain, social services and tax, but it's kind of an interesting finding also. So as international courts are dealing with politically sensitive cases, they may want to actually get some kind of cross-institutional alignment. And immigration being a politically sensitive area, that's exactly what we observe in Kentucky. One example of that, a fairly recent one from a few years ago, is the case of MA versus Denmark. So this case concerns exactly this policy of delaying family unification 3 years for certain categories of refugees, principally from Syria. And in the case, actually both the Danish litigators, the Danish legal team, but also certainly the Strasbourg Court itself, actually looked very extensively to EU law and kind of looked at, okay, well, you know, present day conditions, what's the baseline here? The argument was that from Danish side was, you know, under EU law, you can clearly see you can do it up for 2 years. So a number of other countries are doing that. So why shouldn't we be allowed to do it for 3 years? And the court came down in the reverse and saying, well, you know, the fact that there's a 2-year limit probably means that that should apply to you guys as well. So again, it's sort of an example, and I'll come back to that dynamic of also how, you know, interpretive developments can move across formal regime boundaries and necessitate also political responses from national states, in this case, Denmark. Now, the first question to ask oneself when we think about sort of like what happens as this sort of expanded space of human rights litigation on migrant issues is happening is, of course, that how are these sort of institutionally received in the different Nordic countries? And again, here we see very significant differences. Yeah. So if you look at Finland and Sweden, generally speaking, if there is a individual view from the treaty bodies on a migration-related case, it's automatically almost automatically leads to the given case being reversed. At least that's the sort of empirical picture we're seeing. It can happen by sending it back to the first or back to the second instance, but it tends to be the fact that those cases, initial rejections from the national authorities, are then overturned if there's a finding of violation from one of the human rights committees. Now, that's not the case, however, in all countries. Yeah? So if you look at Norway, there was some concern about this already back in the mid-zeros. And there you have also a Supreme Court that has been sort of dealing with immigration and asylum cases. And one of the things that came out to say in, I think it was 2007 or 2008, was that, well, while the committee views should be given great weight, it also really underscored these views are not right. So there, it's a bit more unclear exactly what goes on, but it's certainly not a uniform picture that these cases are being reversed. And they're typically being sent back against the first instance. In Denmark, however, you have a dynamic whereby cases where there's been criticism from the UN treaty committees are then sort of dealt with by the Secretariat of the Refugee Appeals Board, which is final institution. So Denmark is one of those countries we don't have a further appeal to a court. And they basically take the decision, if it should be reopened, and then at which level. If there's significant new information, it might be sent back to the first instance decision maker, the Danish Immigration Service. Yeah. But in most cases, it will typically then be reopened by the refugee board itself, of course, typically with a new board. And then you would sort of look at the case, and it's been repeated many times also from the chairs of the Refugee Appeals Board that it should not lead to an automatic reversal of the original decision. So in a number of cases, the Danish Refugee Appeals Board sort of reopen cases, and you can sort of say that's kind of a diplomatic courtesy. Okay, you found criticism, we'll look at it again, but then simply upheld its original decision. So there's sort of, again, very sort of different institutional dynamics at play. And my sense is that, or at least the sense of my team, and we sort of three different people that have been working particularly in this area, is that it doesn't necessarily come down to politics. Yeah, there's some countries where you simply don't have a legal mechanism for it. I mean, so I think there's been a single case where Iceland was found to be in violation of the convention, and the response was, well, we don't know how to do that because we don't have a legal mechanism for kind of reversing the case. But it really comes down to sort of ingrained differences in the institutional cultures. Law matters a bit, but it's very rare that you see that something's been specifically changed in this regard. The most sort of obvious example is what I mentioned just before, namely that Denmark then withdrew the financial aid for bringing these cases to the committee. So basically say, okay, we're gonna control that on the input side as opposed to the output side. But the national cultures matter, and they can be very hard to change. It's also a picture we found when we analyze the sort of wider set of legislative amendments that within Nordic countries, there's certain, especially in those countries that have specialized appeals boards, there's a certain resistance to kind of break too much into the internal matters. The best you can do is maybe change who sits in these appeal boards, the composition. That's also why I had to leave the Danish board after 4 years, because then they changed the law back again. So there's only 3 people, and no one is appointed or nominated by the Danish Refugee Council. But it's very rare that you kind of meddle with these sort of internal procedural rules. So the institutional kind of trajectory or culture matters, perhaps more so than the immediate politics. So that's one way of looking at this. Another, of course, is also relates to the input side, is clearly more political. And it speaks to the fact that in some cases you see Nordic countries, the way they adopt new legislation, we typically have national hearing procedures. We're not have anything as fancy as the Myers committee that you guys have. But even so, civil society and occasionally also academics will sort of provide comments on new legislation drafted, kind of point out if there are obvious issues or concerns raised in regard to international human rights law. And a thing that sort of emerged, particularly in Denmark, but we also see it on occasion in Norway, is the political willingness and sort of very open-faced saying, okay, we're willing to take a procedural risk. Procesrisiko is the Danish term. And this basically means that it's been made very clear, maybe also from the civil servants in the Ministry of Justice or the Resort Ministry and from external partners, that this seems like it's going to cause a problem of potential violations with international law, human rights law in this context. And they're simply going ahead anyway, say, well, we're willing to take the chance. And of course, that also speaks to the way these dynamics typically fold out. So again, if you're a country like Denmark, and certainly don't consider the UN treaty body views as binding, but vice versa, have had a few cases with violations in Strasbourg. Well, what you know is that Strasbourg case law easily takes 5 to 10 years to reach a final decision, 8 maybe. And I mean, that's been the cases for some of the previous Danish case law. And, you know, you get 8 years of doing this, probably the world has changed by the time this case would move. So there's a certain, at least in parts of the Danish political landscape and from the legislators, a little bit of a kind of laissez-faire in terms of dealing with this because it's a problem down the road. Another strategy that we see some examples of is what, well, I have a hard time figuring out what to call it, so I've called it downsourcing. And it's that you see legislation that basically pushes the thorny issues of compliance with international human rights law down. And so in Denmark, we have a stipulation in the Aliens Act that was introduced a handful of years ago that basically says that in expulsion cases, the person should be expelled unless it with certainty violates Denmark's international obligations. Yeah, that's a very peculiar formulation, and it's a formulation that the people I know in the appeals board and civil servants, etc., they hate because it puts it on them to draw exactly the line. A similar dynamic has happened in connection with the Danish cessation policy in regard to Syrian refugees, in the sense that, well, there's then an exception to the main rule of cessation in regard to issues where there might be Article 8 issues on family life rights. And again, then it becomes, I mean, there's not very strong, clear guidance from the legislator in terms of how this should be interpreted. Of course, it doesn't help that you might argue there's not super clear guidance at the international jurisprudence either. But we'll come to that. Yeah. And then in a very few cases, you've actually seen, and I don't think there are examples of that from other countries in the Nordics than Denmark, that there is this sort of like open-faced denial of a given rule. Typically not a judgment, but the sort of existing rules. And the historic example of that is to the right here, where a former Minister of Justice decided to ignore, also in that sense, the Danish legislation that had been adopted, much to his demise. This liberal Danish Aliens Act from 1983. And so he basically gave an administrative order to stop processing family unifications for Tamil refugees. And it ultimately led to an impeachment case, the first at the time in 100 years. Interestingly, it's not so many years that we had another minister that was again warned against that what she was doing in terms of separating underage couples in asylum centers without an individual hearing. Might violate the Convention on Rights of Child, but also basic principles of justice. And again, she used the word processrisiko in terms of saying this. And some years later, indeed, the government had turned at this stage that there was another of these impeachment cases, and she was also found guilty and sentenced to, I think, it was 3 months of that she could serve at home with like an ankle monitor. She's now leads a new political party that seems quite successful. So we'll see. Weird things are happening. But that's very much the exception. Yeah, and I think the times we've done it hasn't gone super well. So it's really not the norm. So that takes us to then the last space, which is sort of the strategic outlook that Nordic countries, and again, I'll speak mainly from the Danish example, have taken in terms of then dealing with international jurisprudence that may not feel welcome in terms of migration case law. And the first key dynamic that we see is what you might call post-judgment legislative amendments. And it could sound innocuous because, of course, if there's a finding of a violation that relates to a specific rule, you might expect the country to simply change its legislation. But the way the legislation is being changed is far from always straightforward and also contains very strategic elements. So the first example here is not a case concerning Denmark, but it's the Sufi case, which, of course, as you will know, came on the back of a Dutch case from the EU court, Elgefati. And so a similar finding was applied here, and this general basis for protection following significant conflict and violence and harm to civilians. And that was then reinterpreted by the European Court of Human Rights. So another example of that sort of interpretive link being created across regimes. Now, of course, this was then a UK case, but it also became a particular issue for Denmark. Yeah? So Denmark had been able to sit Elgefati out and simply take note and say, well, you know, may mean that this thing that we run around saying, namely that we abide by the common European asylum system, and that's a kind of a nice thing to be able to say in order to have our parallel agreement on the Dublin system. It may not hold entirely true, but at least the Fetchy judgment was not directly binding. With Sufjan Elmi, certainly it does become binding and sort of starts influencing Danish legal practice. And of course, when Sufjan Elmi came, the situation that was under concern in Somalia at the time was already kind of moving down. But it meant that when we saw the rise in Syrian refugees around 2015, the way that Denmark responded was actually saying, okay, we need to now hedge in the legal effects of Sufjan Elmi. And the way they did that was by inventing a third asylum category. So under EU law, we have, of course, convention status and subsidiary status, and that has been a thing that also has existed in Danish law and assumed Dutch law even before the common European asylum rules. So Denmark now invented a third category with even fewer rights, shorter residence permits called temporary asylum. One of the things there was, of course, the 3-year rule on terms of when you can apply for that application. And it was seen as a sort of a very effective deterrent for Syrian refugees, exactly because, well, if you weren't politically if you were individually persecuted based on, say, your political opinion or something else, you may be able to flee, and your family would be expected to be in safety for a period of 3 years. But of course, if you're fleeing from generalized violence, that's not the case. So it probably really mattered in terms of the kind of logic of the approach, and same with the cessation things that came up. So there you see how sort of like, well, it's not just a question of then adjusting to an international jurisprudence, but you quite creatively kind of look at, okay, what can we do? And again, the Danish legal opt-out to the EU plays in, because the different legal geography allows Denmark to invent a third asylum category. And so, okay, yeah, fine, we can do that. And whereas previously there was this sort of almost implicit assumption in most European countries that persons granted protection based on some subsidiary category or status, they would automatically be afforded almost the same rights as convention refugees, maybe save for the UN passport. Then what Denmark really plays at here is a kind of divide and conquer in a sense that, well, it may be that we now have a non-refoulement principle well established in international human rights law, but there's no associated rights catalog for this group of people beyond the generalized rights that flow from the European Convention of Human Rights or other types of general human rights law. So we can basically create different cessation standards, we can create different standards, rights packages in a way that sort of says, okay, we will abide by it, but in a much more narrow sense. And suddenly you get a much more pronounced rights hierarchy. You get different rights packages based on whether you're a convention refugee, if you have the Danish equivalent of subsidiary status, or if you're on this new tertiary status. So that's one example. Another example is the Bjerg case, which came out, that's 7 years now or something like that. I think it was 16, as I remember it. But don't hold me to it. I'm now suddenly sad that this is getting recorded. In this case, it was a case concerning sort of the general Danish family unification policy. And the issue under concern was whether a particular rule back then, the 26-year-old rule, now 28-year rule, was constituted indirect discrimination. The court ultimately found that to be the case. Now, again, you might then expect Denmark to sort of change the rule and make it more liberal. What happened, in fact, was that they expanded said rule to encompass a much wider part of the population. So the net result of a finding a violation was sort of an expansion of restrictive measures, where they previously thought, okay, we can just target those that we really want, and then sort of maintain a slightly more liberal set of rules on family unification for other countries, for other applicants. In this case, it was very clear the response, and it happened almost instantly. Yeah, so it happened within, I think, 1 day of the judgment coming down. The response was near immediate, and that also, of course, suggests that this is something that you've been preparing for. You've had contingency plans. You've been sort of planning out these scenarios of what happens here, what happens here. We now know that this judgment, which I think also took maybe it was later, but at least 6, maybe a lot more years, depending on which year the hours from there. It really means as this was getting close and you sort of getting ready for the final judgment, well, you could start scenario planning in this particular way. And we've seen that in regard to other judgments as well. The last one I wanted to mention is actually a very old case, and one of the few EU cases, at least in the Danish context. It was the MeDiMi case that, of course, you will know also. But what was interesting about that was that it was seen as infringing on Danish family unification law. Yeah, because of course Denmark has an opt-out that would cover the family unification directive under EU law, but it does not have an opt-out when it comes to core values of free movement. And this idea that there is a kind of associated right to family unification in order to make that free movement right effective meant that Denmark had to significantly adjust its family unification law. So here you had a situation where, well, Denmark fully acknowledged, okay, this is the case, we need to comply with this. However, it did so in a manner that basically bifurcated the Danish legislation on family unification and carved it up along completely separate tracks. So you have one set of rules if you happen to be enjoying EU free movement rights and be an EU citizen. You have a different set of rules for sort of the mainstream family unification policy. And that you sort of see that's also a managerial strategy of kind of legislative bifurcation. Of course, what MeDiMi and subsequent adjustments and then these sort of Danish adjustments created was a very prolific transnational habitation dynamic. So we basically got something called the Malmö move, or the Swedish move, in the sense that people would then live on the other side of the bridge between Copenhagen and Sweden, and in that way for a period be able to say, well, we're now exercising free movement rights, and then be able to claim family unification back in Denmark. So very interesting sort of dynamics going on, but it allowed also from a political sense the Danish government to sort of like maintain the core of its restricted family unification policy. Now, coming maybe a little bit to the core of your project also, Jana, it's of course also interesting what happens in these sort of like litigation dynamics. And I already mentioned the MA versus Denmark case. And this was the case where actually Denmark actively sort of did what in another project I've done was called, you might call regime shopping. So it appealed to a formally distinct regime, in this case even a particular set of legal rules that didn't apply to Denmark, in order to justify its national policy on the waiting period for family unification for 3 years. Ultimately, it backfired, as we talked about. The court appealed to exactly the same rules and said, well, you know, then 3 years too long, if 2 years is the baseline under EU law. And in this case, actually, Denmark has now adjusted it down to 2 years. So this is a case of Denmark simply kind of complying with the spirit of the international jurisprudence. But the interesting thing is that that type of dynamic, appealing to a rules under an adjunct international legal framework, has been seen a lot in these human rights litigation concerning migration. I mean, the most prominent examples are probably the search and rescue cases, where, for instance, in the Hersey case, Italy made a big deal out of sort of appealing to the SAR Convention and related issues under the law of the sea as a way of sort of moving its responsibility of interpretation under the European Convention on Human Rights. Again, the European Court of Human Rights did not buy that, but it's been a litigative strategy that we've seen in a number of cases. We've of course also seen it in regard to appeals to bilateral, either binding or non-binding agreements. Most recently in the UK case concerning Rwanda, that's of course in this case the UK Supreme Court, but back behind that was actually the successful Rule 39 injunction. So that's one dynamic we see in this case. The other we see is that some of the Nordic countries have also joined these sort of like peer mobilization networks of trying to sort of mobilize third-party interventions by governments before the two sort of major European courts in this regard. And this table here is stolen from Baumgartel, who's done fantastic work on exactly this issue. Beyond his great book, he also had a chapter in a book I published a few years ago as an edited volume that I'll return to in a moment, but where he basically also looks at these different strategies, sort of prior, post, and during litigation. And what's interesting here is that the sort of dynamic we see here really started with this case. Which, as I remember, was also a Dutch case. Is it right? Ramsey?
Yeah,
It's Dutch, yeah. So what happened in Ramsey way back when was that, again, this was a case before the European Court of Human Rights, but suddenly during an EU presidency meeting, the United Kingdom, who had the presidency, alerted the other EU member states to the fact that this case was pending. And by the way, it might prove a very useful opportunity to put some pressure on the European Court of Human Rights to push back on the absolute nature of the non-refoulement prohibition as it is applied under Article 3 of the European Convention. Now, that may have been a bit premature because it seemed as if the Brits may not have fully coordinated with the Dutch, or at least maybe the Dutch got cold feet. So ultimately, I think the Dutch actually withdrew the case. But it started a wave of peer mobilization. So around migration cases, you've seen a sharp increase, especially sort of principled migration cases before European international courts. You've seen sort of a high number of submissions from third parties. And at least Denmark has also been part of that application, also in other Nordic countries, rarely leaving the fray. And you could say, well, I guess the Danish government might have wished that it also worked in reverse. But the thing is, of course, that because of, again, of the legal bureaucracy, it's not as clear maybe that the Danish cases that have been before, for instance, Strasbourg, has had the same kind of widespread impact for other countries, exactly because it often was about making use of that expanded sovereign maneuverability afforded by not being bound by EU, for instance, family unification or the asylum directives. So an interesting dynamic also in that regard in terms of kind of signaling to the relevant institution that, this is an issue that has widespread concern and interest by several states in this regard. And you sort of see this. Of course, there's an interesting case of mobilization on the other hand, where of course you also seen sort of like increasing mobilization and coordination among civil society organizations, international organizations like UNHCR, etc., in terms of also having these third-party interventions where possible. Now, that brings me on to the next example, which is again kind of almost coming back to the beginning, and which is about sort of cross-institutional diplomacy. So again, sort of many things might happen at the level of government agencies and the political level. But one should not underestimate also the kind of microdynamics of what's being played out between the different judicial bodies at the national level. So one of the significant responses to this increase that you saw earlier in UN Human Rights Treaty body litigation on migration issues in regard to Denmark was that the Danish Refugee Appeals Board decided to go on a visit to the UN treaty bodies and meet with all of them in Geneva around 2018. And the point here was really to kind of sit down, explain everything about the Danish asylum system. It was also good timing to do it because they felt that, at the time there was this huge recognition rate. So we had for some years recognition rates, if you combine first and second level, almost hitting 90%. Of course, it was because those that arrived were very self-selective. It was very particular nationalities, principally Syrians, Eritreans, and stateless Palestinians. But they also felt that maybe the UN Human Rights Committees were operating under a kind of misguided notion of Danish asylum and immigration law, because they felt, well, at the time there have been all these negative stories in international newspapers about new legislative initiatives. So this comes back to the negative nation branding, the terrorist things, and indeed that had been pushed also sometimes actively by the Danish government. But in fact, very few of these restrictions actually impacted the assessment process itself. And I think that's actually true. I mean, the Danish Refugee Appeals Board was somewhat right to say, well, you know, we have not suddenly started deciding these cases in any way different than what we used to do 5 or 10 years ago. So, I mean, what is behind this huge increase? I should also say that I have actually decided and been part of rejecting claims that have then received criticism from at least one of the UN treaty bodies. And I may be hugely biased there, but part of the response there was also a sense that some, not all, but some of the UN treaty bodies would go very far in terms of in performing a kind of credibility assessment on the back, where in a situation where they hadn't actually been party or had access to the initial more substantive proceedings. So there was an issue of negotiation there, and there was sort of simultaneous with kind of pulling the money from the Danish lawyers. The sort of institutional notion was to sort of also, in a sense, try and rehabilitate the sort of view of the Danish asylum legislation. I mean, there are also elements of the Danish asylum system that should really be positively mentioned in this regard. We have automatic appeal, we have free legal aid, etc., at least as compared to certain other European countries. So there was something to say. And it was an interesting dynamic. It's very hard to gauge if it had any kind of effect. Again, we have seen a drop in the number of cases that have come, but it's harder to say if it had a very significant impact on the outcomes, but maybe a little bit long-term study on that. And now I know I've been talking for very long, much longer than I expected, but just to round off and then I'll conclude. The last thing, of course, has been sort of, you can say, and sort of maybe a weapon. The ultimate weapon has been sort of more direct political pushback and attempts at international reform in regard to these very institutions. Yeah, and now Denmark has a glorious history of trying to international reform, also the refugee regime, with early initiatives dating all the way back to the 80s, and now, of course, talking about wanting to upend territorial asylum. But in this case, it was actually when Denmark had the presidency of the Council of Europe and started mobilizing for getting a new declaration. So these political declarations from the Council of Europe vis-a-vis the European Court of Human Rights, it's not a new thing. We've had several before, the Rights and Declaration, etc., that also, by the way, partly to issue with immigration, and maybe behind also then the drop in the Rule 39 implementations. But in this case, Denmark, at least in the national context, very clearly sold it as being about limiting the European Court's role in regard to asylum and immigration cases. And it may not have been the full motivation. I think parts of Danish government and certainly civil servants and judges were also concerned about the case overload, the long processing times, other things, subsidiary principles more generally. But it was certainly how you pitched it in Danish media as sort of this being very central. And what happened was that the Danish government then released a first draft, which is the one down here. This is the final version. And that, among many other things, also concerned these two particular paragraphs that basically, on the one hand, kind of reaffirm something that you'd also find in the Brighton Declaration, this idea that the court should not be a court for instance as an immigration appeals review, and this idea that, in a sense, you should maintain a degree of subsidiarity in terms of revisiting evidentiary procedures, in this case, maybe credibility procedures performed at the national level, unless it seems clearly arbitrary or manifestly unreasonable. And then secondly, this clause was also very particular and seems very much in sync with the sort of the narrative that the Refugee Appeals Board was trying to convey to the UN treaty bodies. Is sort of like, well, you know, I mean, fair enough that you have some immigration cases if you're dealing with Greece in certain periods where they're completely overloaded or don't have effective procedures, or pick up on countries where the recognition rate is less than 5% year after year. But, you know, we would like to maintain that we have an effective and fully functioning domestic procedure in this regard, and we believe it's operating fairly. And so they have this clause, which in that case, they should avoid it in the most exceptional circumstances. Really quite strong language. Now, what happened here? very interesting because I think the Danish government felt that, well, this would be an appealing issue to a number of European states, and certainly not the one to fight it out over. But even if the Danish government actually had secured also in the context of this debate the support by the main Danish human rights organization, the Danish Institute of Human Rights, my former workplace at the time, no longer because I had moved to Sweden. But there was a very staunch defense of the declaration from the former director of the Danish Institute of Human Rights. And it helped sort of like, in a sense, promoting it. There was a very vivid academic debate. If you want to read some of this, check out Egil Talk, the blog of the European Journal of International Law. There's some fierce inter-Nordic discussions going on between the sort of Danish promoters of the declaration and particularly Norwegian sort of detractors in this regard. Ultimately, however, what happened was that there was a strong mobilization. It was partly launched by the other former workplace, the Raoul Wallenberg Institute, who sort of lobbied very strongly against, in particular, those parts of the declaration that singled out specific issue areas and did so quite effectively. The other area that was singled out in the original Danish draft was situations involving international armed conflict, the whole international humanitarian law versus human rights law kind of nexus that has also been a sort of strong interest for years. And it got weeded out on the basis that, it was argued and a number of countries ended up being convinced that if we start thinking out particular areas, there's going to be no end to it. And I mean, just imagine what's going to happen to freedom of speech, freedom of press, all sorts of other things if we turn to certain parts of the membership crowd. So that ultimately the declaration contains absolutely no specific word on the immigration, certainly nothing to the effect of the first draft. That got weeded out. It does say a bunch of things about subsidiarity, dialogue, other things, maybe good things also in some respects. The question, however, is whether nonetheless the European Court of Human Rights heard a certain signal, even from the draft. And it's certainly clear that, and I've been arguing that in a few places, that if you look at the jurisprudence in immigration cases following the process around the Copenhagen Declaration, the court has taken a significantly more restrictive turn, in some cases even reversing on prior jurisprudence. I'm thinking in particular about the Spanish enclave cases, but also a number of the Eastern European cases on detentions, etc. The visa case might be more obvious because it would have been a big step forward if they had taken it up, but still. So there is at least some kind of sort of suggestion that there has been a signaling effect, maybe not only from this, but at least also in part from this. Now, I'm going to conclude very quickly, and then we can then talk more about what I mean by some of these things. So I just want to leave you with three things. The first is that whether we look from a Scandinavian perspective or an international perspective, the immigration domain has been, on one hand, a main driver for sort of Scandinavian strategic legal thinking or creative legal thinking, as I think I've called it in one piece, vis-a-vis international human rights jurisprudence. It sort of put them into a completely different gear. They are still sort of generally portrayed as good compliers overall in the international human rights system, but it's certainly where you see most effort in terms of sort of creatively repositioning self using these different types of strategies that have been exemplified. And you could say vice versa. The Nordic case law has also really helped shape how, especially the UN treaty bodies, look on key issues related to migration and asylum. And the second conclusion we'll leave it with is simply to expand that argument and say, I think, and I hear again cite Lloyd's work, I think this isn't clearly the case across a whole slew of different countries. So he's been documenting this much more broadly. He calls it part of the game, that this is increasingly a routinized institutional dynamic. It's not exceptional. It shouldn't cause us to come up in arms. It should be seen as sort of the everyday practice of dealing with growing human rights jurisprudence, which is your starting point for your project, and in that light to try and recoup what I call sovereign maneuverability in some degree of the word in light of that. And the third and final argument is to simply say, well, what transpires from this combination is, of course, a more managerialist outlook to international human rights law. And I think that's at least to me a good way of looking at it. Others have used that word as well, as Mr. Hansen among others. And it suggests something that is neither kind of denialist. It's not simply a kind of critical legal studies a la Koskinen or realist IR argument about states only respect international law when they want to. But nor does it fall into sort of or fits the category of liberal theories around transnational legal process, etc. Because it doesn't mean, there's plenty of transnational legal process, but it may be much more evolving around state strategizing than it does around legal practitioners aligning around a certain teleology or sort of liberal interpretation as previously assumed. And part of what I've been doing with people from this university, principally Tanya Alberts, but also many others, have been trying to actually expand that analysis and find examples from other fields. I'm certainly not suggesting that it falls across the fulcrum of different international legal issues. Plenty of areas where there's still very strong and reasonably uniform support for international law. But it may be something that to deal with for a range of issues where states have very strong political interests, be it security law, social welfare law, issues of immigration. And you can find more examples in a book called The Changing Practices of International Law, where we try to assemble some scholars working on different empirical fields to show similar types of strategies being used. And that also suggests that we can talk also about that in the discussion, if you'd like to, that of course the types of strategies that I have identified here probably derive also from other case law areas, and vice versa, that the types of strategies more specifically developed in the concept of immigration are likely to find broader use in regard to other types of claims, both before international human rights law, of course, and other international legal institutions. Thank you very much.